I am Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we focus on India, and in particular, India's finalization of its long-awaited landmark privacy law, the Digital Personal Data Protection Act. After years of debate and drafts, India has officially notified Digital Personal Data Protection Rules of 2025, which give full operational life to the DPDPA of 2023. That's a mouthful. But what this now means is that we have rules that are now going to mean that the DPDPA is no longer theoretical, but is an area where the law will soon go into effect. This marks a watershed moment for the world's largest democracy and one of its fastest growing digital economies. The new law introduces a consent-centric rights-based regime that applies not only to businesses in India, but to foreign companies offering goods and services to India residents, mirroring global standards like the GDPR. The rules are detailed and prescriptive, and we've covered some of them on prior episodes, but we wanted to revisit these, especially given all of the attention that India's new law is getting over the past few weeks and over the coming months. And that's because implementation and compliance deadlines are now certain. Implementation will be phased over 18 months, giving organizations time to adapt, but also time to be able to manage what is going to be a potentially significant compliance burden. Companies will have to make important investments, things like enhancing data architecture, consent flows, and their breach response processes. To unpack what this means for businesses, global strategies, and the future of privacy in India, I'm joined by my guest, Stephen Mathias, partner and head of the Bangalore office at Kochhar Company, who is also the co-chair of the firm's technology practice, and also my partner, a returning guest to the podcast, Charmian Aw, in our Singapore office. Charmian leads our APAC practice and has brought many companies in down the line of their compliance journeys to cover all aspects of APAC privacy, including those in India. I'm excited to be joined by Stephen and Charmian to discuss the key features of the DPDPA, its alignment with global norms, and practical steps that organizations should take now in response. Stephen, Charmian, welcome to the podcast.
Thanks, Scott. Really good to be here.
Great to be here as well.
Stephen, why don't we see if we can kind of get started by just getting an overview about what is happening most recently with the DPDPA. In particular, I know this has gotten a lot of traction and news over the course of the past few weeks, even though this has been a law that had been announced a couple of years ago. What is driving kind of the new focus on India's new data protection law?
Sure. So just to give you some background, I think it was more than 7 years ago when the Indian Supreme Court had passed judgment which stated that privacy is a fundamental right under the Constitution of India. And during those hearings before the court, the government had announced that it was going to draft a privacy law, and it appointed a committee to draft that law. And through that, we went through, I think, 5 different drafts before we finally, in 2023 August, the government released a draft in Parliament and got it passed in a matter of a few days, assented to by the President immediately. And as with all Indian statutes, it comes into force whenever the government notifies the date of its effectiveness. We then went through a period of more than 2 years where the law was passed but not yet in force. The government had to prepare a bunch of rules which implement the law. And that took time. There was a draft rules that was circulated, and then the government worked on finalizing those rules. And so it was just a couple of weeks back that the government decided to notify the rules, to notify the statute as well. And there's largely a three-stage process for the statute coming into force. The first one is the setup of the Data Protection Board of India. So the provisions enabling that are already in force. Then 1 year later, which would be November 13th, 2026, provisions on consent managers will come into force, which means those who want to provide that consent mechanism as a service, they can be registered from that date onwards. And then 18 months from the date of notification, which would be May the 13th, 2027, that's when the bulk of the law will come in. Having done that, the concerned minister then announced that they might bring the law into force 1 year after notification rather than 18 months, which would be November 13th, 2026. But we still have to wait for whether they're going to change that for now. But as of now, the big important date is May 13th, 2027.
And Stephen, so I guess one of the new developments has been that now there are real timelines and real deadlines associated with compliance. You mentioned around the rules, were there substantive changes to the law that had been announced a while back and as part of these new developments, or is it really focused on the timelines that now have become more real?
I wouldn't say substantive, but I think there is significant substance and meat that's added to the law through the rules. So when you look at notice requirements, I think it's become clearer that we're heading the GDPR way on consent. If you look at security standards, there's a fair bit in there on that as well. And there are other provisions relating to retention and so on. Most of that was there in the draft rules, but it is an addition to the statute.
Fantastic. That may be the place to go next to try to maybe understand what are those key features, those key components of the DPDPA, and in particular, how can clients start to appreciate what their significance is. You were so kind to join our prior podcast, probably a couple of years ago now, where we talked through some of these requirements, but it would probably be good to get a refresher on kind of what does this new law require and what are its most significant requirements for global businesses. Maybe from your perspective, maybe starting with the key question, to whom does this apply?
Sure. So it applies to anyone who is processing personal information. But I guess cross-border issues are really important here. So if you are processing personal data outside India, that is personal data of persons in India, then the law could be applicable to you if you're offering goods and services in India. What that means, we'll probably have to build the law on that. But there is some supporting jurisprudence. You'll have it under GDPR, but you also have it under some provisions in Indian law as well. So I think anything that involves focusing on the Indian market, particular pricing for Indian customers, having sales agents in India, sales in Indian rupees and all of that, then the law would be applicable to you. So that's for those who are processing personal data of Indians outside India. Then you have the large offshore industry in India, the BPO and the call center industry and so on, who are processing the world's personal data, really. And so the question is, does the law apply there? By and large, the answer is no, the law does not apply there. So if personal data of persons outside India is processed in India on the basis of a contract with someone from outside India, then most of the law will not apply. It's only the security standards will apply. So those are, I think, the two key issues surrounding, who the law would apply to.
Thanks so much, Stephen. That's really, really interesting, especially the BPO exemption. Coming from APAC, we tend to take GDPR as a reference point. It's just a good strategic way to start the discussion around, kind of what else do we need for compliance across the, frankly, quite fragmented regional landscape of data protection laws in Asia Pacific. If you were advising a client that already had GDPR compliance in place, in particular, right, a notice, say, that was reviewed for GDPR standards, how would you advise them coming into India with the DPDPA and the rules in place? around such notice? Would it work for India, or would there need to be tweaks specific to India?
Great question, Charmian, and I think that's probably the most important question to ask regarding DPDPA. Grounds of processing is the heart of data privacy law. And so the question really is, what are the main grounds for processing? So significantly, you have legitimate interest under GDPR, and that concept is absent in this law. My understanding is the vast majority of companies doing business in the EU use legitimate interest as a ground for processing. And the vast majority of privacy policies that I've reviewed have used legitimate interest as the main ground for processing. So if legitimate interest is not there in India, that means you can't use legitimate interest. There are two types of exemptions under the law. So one are exemptions to the statute itself, and the second are exemptions to the requirement to obtain consent. So there are a few there. For example, most of data processing of employee data would not require consent. But again, I would say most of the personal data being collected and processed would require consent. So here's the important part, which is the definition of consent is pretty much the same thing as under GDPR, which is free, specific, informed, through an affirmative action, unconditional, and so on. When you look at the jurisprudence in the EU on what consent means and how you obtain consent, you look at guidances from the EDPB and before that, it's a very high standard. And that's essentially the standard that's going to be implemented in India. In the rules, they've gone on to say that they're expecting to see an indexation of content of what personal information is being collected and the purposes for which it's being collected. And so when you look at it totally, you will see we are pretty much going the GDPR way when it comes to obtaining consent. So it's a very high standard. So I think to answer your question at the end, I would say if you have a privacy policy or notice and you're GDPR compliant, but you're using legitimate interest, then you would not be compliant under this law.
Got it. And also, I presume that the 22 gazetted languages that recognized in India will need to be also taken into consideration when obtaining those consents, because you need to ensure that you are demonstrating if it has to be opt-in, etc., and specific. You need to convey the purposes in a way that is understood by the reader or the recipient or the data principal.
You're right. And, when the statute first came out, we were hopeful there would be some liberalization of that requirement of 22 languages. But that's not happened. So if a person is to be given a privacy notice and that person opts for any one of those 22 languages, then you have to give it to that person in that language. That's how the law is written. Well, I think with technology being the way it is and with AI and so on, perhaps it's just a matter of, subscribing to the right technology to translate.
Yeah, and also just one kind of comment around consent managers. Are they quite unique to India? Could you maybe walk us through this concept of a consent manager? My understanding is that it isn't novel. It's not completely brand new in India because it actually borrows off, I think, the sectoral type frameworks a little bit. But maybe talk to us about what the consent manager role is and how you see that feeding into the obtaining of the consents that we've already been discussing.
Right. I think what's different here when you compare with other countries' laws globally is that the law specifically sets out the opportunity to use a consent manager. I mean, I don't think you'll have a law which does not allow you to use a third-party technology provider to implement your consent framework. And so in that sense, it's not new. And that's essentially what the law is about. It sets out a process, a framework for having consent managers. They have to get themselves registered and so on. And then they can provide services to data controllers to help them implement the whole consent mechanism.
Fascinating.
And Stephen, do you think, if I'm thinking about this consent component and the broad requirements for obtaining different types of consents, but it sounds like maybe not all the time in the employment context, what does this look like for global businesses And in particular, consent sounds great on paper. Oftentimes it's difficult to implement and to track, right? To say that Scott Loughlin has provided his consent and to what it is that I've provided my consent and when is that consent valid? When is it invalid? What have I agreed to? What I haven't agreed to? When is it that I revoked it? When I didn't revoke it, right? The consent managers obviously will have a key component there. But from a product perspective and from a service perspective, what does this look like? Is this something that we are going to have kind of an explosion of cookie banners that we may see under the GDPR in the EU, increasingly in the United States and elsewhere? Or does consent look like it's something different?
I think we are essentially going to be implementing consent the way GDPR envisions consent, because the language is the same. So I've seen a few, not many, but a few privacy policies where you pretty much set out in a tabular format, what personal information is being collected and for what purpose, and then you list each one separately. So I think that's pretty much what we are going to be expecting. So if you're talking about an explosion in the EU and in the US, it's probably going to be bigger in India because the US, across the country doesn't have this kind of requirement to this extent. And in the EU, they're largely using legitimate interest. So I think it's going to be have a much bigger impact here.
Interesting. Did you see this evolving though? I'm just sort of putting you on the spot here, but the reason why I asked that is primarily Asia is consent first. Singapore was consent first when we rolled out our Personal Data Protection Act. But then subsequently there was an amendment, reform, right, to legislation where we introduced legitimate interests and other, sort of lawful bases for processing, in part to align with the GDPR, but also in part to recognize, I think, the constraints of consent that Scott perhaps alluded to as well. So in your view, do you think that this will be it, or do you think that India will also start kind of considering other, legal grounds for processing?
So I think what might happen here, and this is, if you look at Indian, regulatory history, you see many, many instances of regulatory overreach, where the law might say one thing, but the practice is something less than that. And so it's possible that could happen here in the sense that because we have all this jurisprudence in the EU for the same language that defines consent, it would seem logical one would go the same way. But perhaps businesses will try their luck and start with simpler forms of consent and see how it goes, and then wait for the law to evolve and see what the Data Protection Authority has to say about it. So that's a possibility.
And Stephen, how are you thinking about the questions here around, does this law apply outside of India? You touched on this when you were talking a little bit about the scope and to what extent the law would apply to businesses that are not operating in India. You mentioned kind of using India's currencies and different types of targeting for services as baseline. How are you seeing this to impact global businesses who may be doing business in and out of India? And then importantly, kind of what are the requirements around either data localization or cross-border data transfers that may be of relevance to global businesses?
Sure. So I think that if you're a business outside India and you're not targeting the Indian market, but it's an online business and anybody can become your customer from anywhere in the world, including India, then I think the chances are high that you do not need to comply with Indian law because you're not doing something very specific about offering goods or services to the Indian market. Coming to data localization, the 5 years that we went through different drafts, we saw drafts that were, generally a lot stricter on data localization. But this one, at least in the statute, is fairly liberal. So essentially, there's no data localization that's prescribed, but the government has the power to restrict the transfer of data to specific countries, what I would call a blacklist. I would think that there are probably two types of countries out there. One would be countries which do not have data privacy laws of a sufficient standard. The other would be countries that have, hostile relations with India. And there has been a lot of concern in India about Chinese businesses and Chinese apps gathering and processing Indian data. So I think high on that would probably be China and Pakistan. Whether it would be a prohibition or it would be, some form of restriction, we have to wait and see. The government hasn't notified yet on that. There are a few other provisions. So in the rules, for example, the government can restrict transfer of personal information and traffic data of significant data fiduciaries to, for example, state instrumentalities of state or foreign governments and so on. So there are a few other provisions there, but by and large, the main provision is the one which gives the power to the government to make a blacklist of countries and to restrict or prevent personal information from going there. Having said that, we must keep in mind that there are sectoral regulations in India already in areas like payments, banking, insurance, and telecom, where personal information being transferred out of India is already restricted. So we have to consider both types of laws, the data privacy law as well as the sectoral regulations, when we consider data localization.
You mentioned earlier, Stephen, and this is something that I wanted to just kind of dig a bit deeper into. There is a BPO exemption, right? And you did mention the provisions that would still apply, as including security. Could you tell us how this would work in practice? So what would clients, group companies that have obviously part of their BPO in India, what do they need to think about to invoke or rely on this exemption in the DPDPA? And what else do they need in spite of the exemption? So would it be, say, an incident response plan that is specific to, India's DPDPA, which, I mean, at the moment, it seems quite aligned with the GDPR in terms of the 72-hour notification timeframe, although with the digital omnibus in Europe, I understand they are also relooking at the 72-hour and relaxing that somewhat. But also, I guess, global clients that we act for are particularly kind of interested in the cert-in 6-hour reporting mandates and obligations as well. So could you just walk us through how you would advise that sort of client?
Sure. So I think the first thing is when a company is looking to offshore or outsource to India, they might want to consider what's the standard of data privacy law in India. And so perhaps there may be a bit of a setback when they find the law is not actually applicable. And it's only the security standards which are applicable. So I think that's the first bit to it. I personally don't think that's a problem because I believe that in the whole area of cross-border transfer of data, the law that applies should be the law of the source. And so if the data is coming from Singapore, it should be Singapore law that should really determine, how the personal data is collected and what purpose it's collected for and whether consent is obtained and so on. So so I think that's the first part to it. By and large, then personal data of end customers, let's say a bank and all of its thousands of customers being processed in India, all of that would not be covered by this law. Then we go on to vendors and we go on to employees. So the business will have vendors who are involved in all kinds of services to it in India. So all of them, that data would still be covered by the law. When it comes to employees, there is an exemption from the requirement of obtaining consent And there are some ancillary exemptions added to that as well. But the main thing here is there are three kind of buckets of exemptions from obtaining consent in employment. So the first one is just called employment purpose. The
Mm,
second one relates to businesses' need to prevent itself from losses and maintain security and so on. And then the third one is providing benefits to employees that are requested for by the employees, not by the employer. So these three buckets. And what we have found is that maybe 80-90% of processing of personal data of employees are covered within these exemptions. The key one, I think, which is not covered is probably where a business either, provides its products and applications to employees to use. Then they become more customers, or they use employee data or employee images, videos, things like that for marketing purposes. So those, again, that's not an employment purpose. So those are situations where employee data would not be covered by the exemption. Yeah, so I think that's pretty much covers what I think is the landscape of personal data that a global business that's offshoring to India would have to deal with.
right. And what about the breach reporting requirements? Do you think that the DPDPA adds more compliance burdens on that? And can you talk us through what you would, advise a global client that's kind of, pre-DPDPA having to deal with the 6 hours of cert-in reporting requirements, and then now you have an additional kind of layer with regards to personally identifiable information with a 72-hour time frame. So just walk us through what the requirements are and how they should navigate those.
Sure. So I think that leaving aside the lack of legitimate interest and the consent standards, this is the other big one, the one where the DPDPA is more stringent than most countries in the world. So you have a requirement under this law to notify the authority, the Data Protection Board of India, and to notify the data subject as soon as possible when there's a data breach. And there's no threshold that's like related to risk and so on. So every single data breach has to be reported. That's already two reportings. And then within 72 hours, you've got to make another reporting to the Data Protection Board of India with more detailed information. So that's a third one. And then we have CERT, the Cybersecurity Authority, under a different law, where reporting has to be done within 6 hours. To be honest, the last 20 odd filings we've made for clients, in not a single case has a client reported within 6 hours. And it's not like the authority has even questioned, why did you not report within 6 hours? And we've even seen reportings after 2 weeks or even after 2 months. I think that's just based on the nature of how cybersecurity incidents happen and how they are investigated, and how you come to conclusions. So four stages of reporting, which I think is quite excessive and very stringent, going by global standards.
Right. And this also applies to the BPO type companies, right, where the data is foreign data, so to speak. So the incident reporting requirements do apply to them as well. Is that right?
Yes, so I think under the cybersecurity regulations, there are some complications there because this is a server that's outside India, and in most cases, and that law does not actually relate to personal information, doesn't talk about
That's right.
personal information about
That's right.
Indians
Yeah.
at all. So it's a cybersecurity incident. We look at different factors when we advise clients on whether to report or not. And by and large, if personal information, if there's a significant amount of personal information of Indians involved, even if the server's outside India, then they would report.
Stephen, maybe, I think the security angle is going to be of interest to a lot of organizations, especially as, in that way, there is this cross-border kind of global impact. I think another area of interest for a lot of our clients is going to be around the development of AI-based technologies, and how this law may be speaking directly to AI, or perhaps other laws that are on the horizon in India may be speaking to AI. Can you share your thoughts on that?
Sure. So I think by and large, this law is fairly friendly to AI. So one is this whole concept of data minimization. That's sort of missing in this law in the sense that the only requirement is that you must process the personal data for a purpose which you have mentioned in your notice. So if you draft those purposes fairly broadly, then as long as you're within those purposes, you're fine. Significant data fiduciaries, controllers, they have a requirement of a data impact assessment and so on. So they may be treated differently. But by and large, the concept of data minimization is somewhat missing in this law. At the same time, you have the requirement to obtain consent, and consent has to be specific. So whether that means if you list out a bunch of purposes and somebody ticks on a few and refuses on a few, how does that work out? We'll still have to see. But I think only GDPR jurisprudence could really help us out there. Then there's a requirement that where you are using personal information to make a decision on a data subject, then it has to be accurate and it has to be consistent and so on. So those are some of the provisions that are kind of relevant to AI and how it'll play out in the world of AI.
So I just wanted to ask, maybe with respect to the idea of a broad notice and being able to get, those types of permissions that way. You mentioned earlier on some of the more strict requirements relating to consents. How does consent work its way into the ability of using data for either AI training purposes or for AI-oriented product development?
So I think if you draft your purposes fairly broadly, then to cover this kind of activity, then you can do it. But when you list the purposes out, if you list each purpose specifically, and if a data subject refuses some of them, then you can't process for that purpose. But whether a data controller will do that or will just list them all out individually and with one consent, that remains to be seen. It remains to be seen how the authority wants that to be done. So that's the reason why I feel overall it's not a bad legislation when it comes to giving freedom to use personal information for AI systems.
That's really fascinating. I also had a question around kind of comparing the DPDPA sanctions, the financial penalties, say with other frameworks that we're maybe like more familiar with or that are perhaps have been around for longer. Could you walk us through what those penalties look like in terms of, are they pegged to turnover? Is it at a certain cap? And just walk us through what, I guess the repercussions of non-compliance would look like.
Sure. So by and large, it is not based on businesses' revenue or profits, whether in India or overseas. I mean, earlier drafts did have that. By and large, there is a table and there's a list of different violations, and those violations have a maximum penalty that's prescribed there. I think the maximum goes up to about $30 million. The government does have the power to amend that schedule and increase the penalties. But one other thing to note here is that the law does not prescribe for payment of compensation. So it's only a penalty that's paid to the government. There's no compensation that's payable to a data subject.
I see. That's kind of different from the former framework, right? The IT Act and IT rules, where even though you needed to prove some kind of harmful sort of or some kind of loss, there was that right to compensation. Is that right?
Yes, in fact, the current law is only a provision on compensation, nothing else.
I see.
So there you pay compensation if you fail to use reasonable security practices and procedures, and you're negligent in doing so, and it results in a willful gain or a willful loss. So even though the standard is quite high, willful gain, willful loss
Mm,
largely relates to fraudulent and dishonest conduct. And that's the main provision there, and it applies to compensation. Yes.
right. And in terms of this transition period until I think you said it was the 13th of May 2027, if we were to be, working on contracts with counterparties obviously implicated or impacted by the forthcoming, DPDPA consent provisions, etc., what would those contracts look like? Would they still make reference to, say, the IT rules and the IT Act in the interim, or should we already start kind of implementing DPDPA type provisions? What would your advice be for this transition period?
So the DPDPA, I think the key issue is whether the contract would go past the 18-month date of May 13, 2027. And if it does, then obviously you would want to comply with the law for that. The IT rules under the Information Technology Act, Section 43A, are less of a concern. One, because it's almost a voluntary provision in the sense
Okay.
that a business can decide, I don't want to comply because my only obligation is to pay compensation if I'm negligent and if it results in a willful gain or a willful loss. There's also this concept of reasonable security practices and procedures where two parties can agree what that means. And so a data controller can agree with the data subject what that means, and as a result, exclude the IT rules. So I would, as a result, focus much more on the DPDPA rather than on the IT rules.
And then maybe my last question, Stephen, is from your perspective, you advise many global businesses, especially those who are operating in and out of the United States, helping those organizations understand compliance in the EU and develop out their compliance programs. Now we have real deadlines associated with compliance in India under this new data protection law. How are you working with clients now in anticipation of these rules going into effect? What are effectively the do nows, do next, and do laters from your perspective?
So I think for a lot of international companies, even before this recent notification, we've already reviewing their privacy policies and advising them based on the DPDPA, on the fact that it would come into force. So I think obviously one should move ahead and do that. I do think for companies that are not as well organized, and this probably relates more to Indian companies, you do need to do some data mapping and understand what data you're collecting, for what purpose you're collecting it, where it's stored, who has access to it, and so on. So I think for the Indian companies, and particularly those who are not doing business overseas and who have not faced a privacy law before, there's a huge task ahead. For the international companies, obviously they already know where their data is and what they're using it for. So it's a question of drafting a new privacy policy for India or tweaking your additional existing policy to comply with Indian law. To the extent that's possible, because as I said right in the beginning, if it's a legitimate interest-based privacy policy, it may not work for India.
Super helpful. I appreciate that steer. And Stephen, really insightful thoughts on how this law is going to be developed and how is it that organizations may comply with it. Really appreciate your time taking out of your busy schedule, and I'm sure we'll be back at it in the next couple of months as these rules start to become closer and closer in terms of compliance deadlines.
Great talking to you, Scott, and to you, Charmian.
Likewise, Stephen.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.